details why he went into hiding without a phone. And we all know the role phones play in locating people. So he went without his phone, did not communicate with his family, his mother, or anybody, and did not know there was a case in court. When he surfaced due to his poor living conditions and got a phone to call his cousin, he learned of this case, and that's how he came out. And it does indicate, because of the previous incidents of police abductions, he feared. He says in paragraph 16 that he contemplated going back, but he feared likely abduction, torture, killing or disappearance, and went into hiding to preserve his life. So without reading the whole affidavit, which is available for reference, those are the circumstances. And he annexes the affidavit of his mom, Margaret Rukwaro, it's Annexure 3, who also gives the circumstances in which he sought the help of the Law Society of Kenya when his son went missing. He was in a state of distress, mentally broken, psychologically, he was in a state of, she was in a state of distress. And he also describes her son when she came from custody, from hiding, broken, physically distressed and psychologically tortured by the circumstances. So in other words, in a nutshell, the mother of Ndiangui, when going to the Law Society, had reasonable apprehension, which any mother acted the way any mother or reasonable parent would. And also the second petitioner, by going into hiding, the way he relates in his affidavit, it was the way any reasonable person would answer. And I'm asking the court to take judicial notice that pending before these courts, there are various petitions of people who have disappeared, have not surfaced. People who have disappeared, turned up dead. I know of one case, E17 of 2024, 714 of 2024. So I'm asking the court if the court so deems it proper to close this file, close it with the understanding that the circumstances in which the second petitioner and his family reacted were circumstances in which any reasonable person would react just the way they reacted to preserve life. And therefore, to give them that indulgence. We want to thank the court because it gave protective orders. We have had cases of abuse of powers of arrest.
Circumstances under which the second petitioner disappeared in court. The affidavit is self-explanatory and the court has taken into account the second petitioner's concerns that led to his disappearance. He went into hiding for fear of his life, and the steps taken by the second petitioner were not, in my view, extraordinary. The court has also seen the affidavit sworn by the second petitioner's mother and the circumstances that led to her instructing the first petitioner, the Law Society of Kenya, to take up this matter on behalf of the second petitioner. The first petitioner, the Law Society of Kenya, acted based on the instructions given to it by the second petitioner's mother or his family. No offense can be attributed to the Law Society given the threats that have been going on presently. Fortunately, the second petitioner presented himself before this court alive, and it is important that this matter ends here. Regarding the items taken from the second petitioner's residence, the property belongs to the second petitioner in the absence of any claims of ownership by any other person. The police should be able to lease or return that property to the petitioner once they are through with their investigations, if any. On whether this court should take further steps, should stop the police from taking further steps in arresting the second petitioner, I do not see the need to do so now. The second petitioner has been going to the police station and they have recorded statement. The police have therefore no reason or authority to frustrate or torture anyone, including the second petitioner, and should be reminded of the constitutional command that they have to act to the highest standards of human rights. That, I think, is in the Constitution, Article 244, and also the Police Service Act. I do not want to recite it for them. Any threats against the second petitioner can be dealt with as and when they arise. This court need not act in anticipation. All in all, this petition is their matters withdrawn with no orders to courts. I wish you well. Thank you.